Trainers Owners Reform is a reform that comes into effect on the 1st of August 2017. It's been designed to formalise and simplify the arrangements that trainers have with owners to provide a contract arrangement between them that assists in identifying what each party's responsibilities are to each other. The fee notice is the first aspect of the Trainers Owners Reforms, which requires a trainer to, upon beginning training a horse, send a copy of the standard fees notice to the managing owner of the horse, whose responsibility is to ensure all the owners in the horse are aware of the fees notice, and it sets out all the arrangements and costs and charges that are to apply in relation to that relationship between the parties. The fee notice that the trainer needs to provide to the owner is 7 days from when he begins training a horse. He needs to provide the fees notice to the owner, which the owner then has 14 days to respond to. If it's not responded to within the 14 days, it's taken and deemed to be applicable and applies thereafter. The fees notice is issued to the managing owner, and it's the managing owner's responsibility to forward that to all the other owners, and if there are any issues arising, have them dealt with. If there is no response back to the trainer, then the trainer is entitled to assume that that's been accepted, and indeed the rules say it's deemed to have been accepted. The trainer's responsibility is to send the fees notice only to the managing owner, and it's the managing owner's responsibility to ensure all the other owners in the horse are aware of the terms and conditions that have been entered into. It's imperative and strongly encouraged that trainers retain a copy of a record of the transmission of the fees notice, which can be as simple as the email that was sent to the managing owner, or whichever other format they might choose to send their notices, but it's important to the process for future reference to be able to demonstrate that the notice was issued. The rules set out a comprehensive way of dealing with disputes. Essentially, the fees notice is sent, and if we assume that it's been sent and has been accepted and deemed to be accepted, then what the trainer would do is generate his normal invoices at the start of a month and send them to the managing owner or the owners, as the case may be. If the fees are paid, that's great, and if the fees aren't paid by the end of the month, then the trainer can elect to start a process of having those fees dealt with through Racing Australia through the lodgement of a certain documentation. There is a presumption of debt that arises if the debt's not paid within a certain period of time, and the trainer can make application then to Racing Australia, who will come back through to RAWA or other PRAs to put in place different things to address the fees, such as freezing prize monies, redirecting prize monies, or preventing registrations or changes of ownership depending on the situation. In the event that there's a dispute process instigated, the documents need to be lodged to Racing Australia to start that process. And then if it's not resolved through review of documentation or through the process that's available there, the matter can get referred to the PRA or to RAWA for resolution through what's been called the Trainers Disputes Tribunal. And what RAWA's done is appoint an independent, legally qualified person who would be called upon to determine those disputes. So it won't be the stewards and it won't be RAWA officials who will be determining any disputes, because the determination of them will be a commercial process guided by legal precedent, and we've engaged an external legally qualified person who will be called upon to do that. The new system overrides it in so much as it underpins the basis of it. People can have their own agreements, and existing agreements can be recognised, provided that they're consistent with the basic terms and conditions of the standard trainers agreement and the term Trainers Owners Reforms. This is a national system that's been implemented by Racing Australia that comes into effect, as I said, on the 1st of August 2017, and the same rules apply everywhere. It's to protect the trainer in terms of ensuring bills are paid and agreements are set and everyone knows what everyone's responsibilities are, but it also sets out the responsibilities for the trainer in terms of when they need to issue invoices, communications to owners, etc. So both parties have a role to play. It's designed to just formalise what in the past has often been verbal agreements between people where when parties have a dispute it's very difficult to reconcile what the result ought to be, where through this method it's all particularised and written in writing so that hopefully there aren't any disputes, and if there are, well, they can be resolved through reference back to these materials at the start. Yeah, we strongly encourage people to either through the rail website access the links that are available or go direct to the Racing Australia website. There is a very comprehensive and dedicated section of that website that deals with trainer owner reforms with all the information and the pro forma documentation that people need to use through every step of the process, and it'll outline what needs to happen at stages where if accounts aren't paid or invoices aren't paid, it clearly articulates the process that follows from there that has that matter dealt with.